Okay, so we're going to get started. Hi, everyone. Thank you so much for joining us today, for joining us this evening. My name is Andrea Tecpoyo Toltepale, and today we're going to be doing an Immigration 101 presentation regarding what are your options to immigrate. But first, we would love to tell you a little bit about our organization. We are Alliance San Diego. Our mission is to build a collective power for to create an inclusive democracy where everyone can fully participate with dignity. And our approach to this is developing leaders, engaging our community, changing and shaping narratives and policies to protect everyone's rights. And some of our values in our organization include inclusion, compassion, justice, collaboration, and integrity. And so today, our legal rights department is bringing you this presentation. We have our director and immigration attorney, Michelle, as well as our manager and Department of Justice fully accredited rep, Hector, who will be presenting today. Myself, I am one of the legal rights organizers, as well as a partially accredited Department of Justice rep. And then Yolanda, who is also one of our organizers, and she's working on getting her accreditation. Some of our legal services include doing the naturalization process, helping the community with their DACA renewals, green card renewals, TPS, and more. And then the other side of our work is doing education and outreach, which include doing webinars and presentations around topics like naturalization, giving immigration updates, such as the one that you're hearing today. So today's focus, our topics that we'll be discussing throughout the presentation are the following. So family-sponsored residency, humanitarian relief that leads to residency, employment and investment-based residency, the diversity visa lottery program, removal relief, how to avoid fraud, and then at the end we'll be able answer some of your questions. So stay till the end if you have any. And now I'm going to pass it over to Hector to continue with the presentation.
All right, thank you so much, Andrea. And thank you for joining us today, Thursday afternoon, evening almost, to talk about this like 101 presentation. So we really want to talk about the most common ways that people get their residency. And that's what we're hoping to touch on today. This is not a complete list of the ways that you can become a resident, but it's definitely the most common ways that most people in the US acquire the residency. And the most common is family-sponsored residency, so family petitions. And we'll start there. So a couple of factors to consider when talking about a family member petitioning you is who the petitioner is. So the petitioner, for you to petition someone, you need to be either a US citizen or a legal permanent resident. Unfortunately, if you have a visa or you have DACA or any other immigration status that is not resident or citizen, you cannot petition any family member. And then another factor to consider is what relationship does that person have to the person you're trying to petition? So are you an immediate relative or are you a not so close relative in the eyes of immigration, which is very important because, you know, we can consider ourselves being obviously very close to, for example, our grandparents, but immigration might not consider that relationship close enough to warrant a petition. So we'll talk a little bit about that. And that's why we have this title, Are You My Family? And this is for immigration purposes, of course. Only certain individuals are considered family, not everyone that we would think of, like aunts and uncles and grandpa and grandma. Only spouses, parents, children, and sometimes siblings are considered family by immigration. And so that's a very limited amount of people when, you know, especially in other cultures where family is such a big thing. So it's a very limited list of who is considered family in the eyes of immigration. Um, and so you need to consider a lot of different things when thinking about a petition. You need to think about, is your petitioner, see, the person that is being the one asking for residency for that other person. So there's petitioner and there's beneficiary. Petitioner is a US citizen or resident. Beneficiary is the person that is trying to become a resident. So you need to know the status of the petitioner. Are they a US citizen or are they a legal permanent resident? And then you need to think about the beneficiary. Who is this person that you're trying to bring? Are they considered family in the eyes of immigration? If yes, or if they're children, what are their ages? That matters too. If there are children and they're underage, that's one type of case. But if they're children and they're over 21, that's another type of case. And you also have to consider the marital status of the beneficiary. Is the person, if I am a parent and I'm petitioning my daughter and she's an adult, is that daughter married? Is that daughter single? So all of these can make a petition be different. And like I said, aunts, uncles, cousins, grandparents, or patrilineal are not considered. Um, and so when you have all these different types of petitions, there's a lot of different categories as you see here. So there's really two separate groups, and the two separate groups have their own descriptions. One group is called immediate relatives. So these are what immigration considers to be the closest family relationship that you have as a person, as a petitioner. So these are your spouses. So, for example, for me, it would be my wife. These would be my minor children. So these only minor under 21. So any children, like I have a daughter, she's a year and a half almost. She would be one of my immediate relatives because she's my minor child. And parents would also be considered immediate relatives if I am 21 or older. So that's very important. So a petitioner needs to be a certain age to be able to petition you. And for children to petition their parents, the child needs to be at least 21. So if a 21-year-old child is petitioning their mom, that mom is considered an immediate relative. So there's this group called immediate relatives. And like I said, it's what immigration considers to be the closest group. Then we have a whole other group called preference categories. And these are different types of petitions from relationships that immigration says you still can petition, but because the family closeness is a little removed, we're going to have you be in these categories. And depending on what category, you're going to have different wait times. And so we see here that there's 4 different categories. There's category 1, unmarried sons and daughters of US citizens that are over 21. Then we have category 2, which has 2 different categories, 2A and 2B. These are for residents. So a resident petitioning their spouse, that's a 2A. A resident petitioning their minor children, that's a 2A. Note that if they were citizens, these individuals would be immediate relatives. But because they're residents, they're not immediate relatives, they are 2As. Then we have 2Bs, which is unmarried sons older than 21 of residents. So that's preference 2. Preference 3 is married sons and daughters of any age of US citizens married. And the 4th and last category is brothers or sisters of US citizens. So this is it. There are no more different types of family petitions that exist in immigration law, only these. And so when we're thinking of, can a family member petition me, we need to think, do you fit in any of these categories? And if you do not, it means that there's a petition that's not available for you. So I explained to you guys how there's immediate relatives and there are preference categories on the previous one here, right? And so for immediate relatives, the case tends to be really fast. There tends to be no wait time, only the processing times. But for preference categories, there's actually a wait time. It's like when you go to the market and the meat part, I'm Mexican, so this is very common in Mexico. You're going to like the meat section and you have to get a ticket and you're number 3 and you have to wait until they call your number for you to go to the butcher and tell them what you want, right? So it's kind of like that. And here is where they are in line. So if you see here, I know it's kind of confusing. F1, F2A, F2B, F3, F4, these are all the preference categories. And the first date that comes there is where they are in line. So that means that for F1, right now, they are in cases that were filed September 1st, 2017. And if we go back, what is F1? F1 is unmarried sons of, and daughters of US citizens that are 21 years or older. So if I'm a citizen and I'm petitioning my son and my son is 30, I need to wait right now, they're in 2017. So that means I need to wait 6 years for my petition to move forward, for it to be my son's turn to go and file his case. So that's a long wait time. However, unfortunately, depending on what country that person is from, the wait times change and in some instances change drastically. So the 4 countries that have the longest wait times are China, India, Mexico, and Philippines. And they have their own wait times because they have so many petitions that are pending. So the first list that you see here is all the other countries in the world. All the other countries in the world, for example, for an F3 are in March 1st of 2010, if you see it right there. But if you're from Mexico, an F3, they're in June 15 of 2001. So without exaggeration, 22 years. Why does this happen? Because there's a limit on how many visas they can give per country. So if they're only allowing 100 petitions of F3 for Mexicans and 1,000 come in, then they serve the 100 that they said they were going to serve. But now they have a backlog of 900. And next year they can only see 100 again and they get another 1,000. So now they have a backlog of 1,800 and so on and so forth. And it creates these long wait times. We're hoping they change. They kind of do, kind of don't. But this is kind of how family petitions work when you're not dealing with immediate relatives. You have to check where you are. And so how do you start this process? By filing an I-130. The I-130 is an immigration form where you are trying to prove to the US government that your relationship to this other individual warrants a petition. So you as a petitioner, petitioning the beneficiary who is my spouse, my child, etc. And so what you need to do in the I-130 is prove that that relationship is real. So if we're dealing with marriage, you prove that the marriage is real. You prove that by showing evidence of the wedding, evidence of any children you might have together, shared finances, anything you can do to prove that that's a true relationship, you throw it in there. And it's case by case. Some cases require not so much, like the easiest cases are the ones of the mother. It's really easy for a son to prove to immigration that that's mom. Birth certificate is almost all you need for a mom petition because it's really simple. Whereas if it's like a marriage and they're both in their third, fourth marriages, then you have a lot of information to prove to immigration that this is a valid, real marriage. And so every petition is different in the level of evidence that it will require. But after the I-130 is approved, you're done with that step. And what happens is immigration says, we believe that this person is your family member. So they approve the relationship. So now what? Well, the next step is, okay, we approve that this person is your family member. Now that person needs to prove that they qualify to get residency. And so this can be done one of two ways. It can be done in the United States, or it can be done outside the United States. And it really depends case by case. Um, for the people that are outside of the United States already, the process is called consular processing, and that is the process of, let's say, I am married to someone that is from, I don't know, Egypt, and I want to petition that person to come here. Obviously, they're in Egypt, so I file the I-130, and once it's their turn to start working on their application, and they have to go to the interview, that would happen in the U.S. Embassy in Cairo. And so you work with the embassy of the US in that country. So that's called consular processing. The other way to become a resident is in the United States, and that process is called adjustment of status. And what that means by the words is that you're adjusting the status that you currently have to residency. So this is usually limited only to people that enter the U.S. legally, which is why it's so prohibitive to a lot of people. An example would be somebody that entered with a student visa, or somebody that entered with a tourist visa, and then they get petitioned and do this process, then they can do it inside the United States. Of course, it really varies. Every case is different. But briefly, to not get into a lot of detail here, this is kind of how it works when you're doing the processes here in the United States, adjustment of status. And what they'll be looking for is both in the embassy and in the US here, they're going to be looking for a couple of things to make sure that you're admissible. They're going to be looking at your immigration history. They're going to be checking if you've been deported before, entered illegally before, detained before, really checking all your immigration history, any criminal history. They're going to be checking your financial stability to make sure that when you come in as a resident, that you're not going to be a burden to the government, that you're not going to become what we call, or immigration calls, a public charge. So they're going to assess your finances and those of your petitioner. And also medically, they're going to check that you don't have any communicable diseases and that you have all the vaccinations that the US requires. So there's a lot that goes into this, both if you do it outside in consular processing or inside adjustment of status. And when you're doing adjustment of status, there is an exception to waiting for one step and then to the other one. Because when you're doing adjustment, you can just turn everything in at the same time. You don't need to turn the I-130 in first and then wait and then get it approved and then move on to step number two. If you're doing an adjustment and you're being petitioned by an immediate relative, which we said was a spouse, child under 21, or a parent, then you can just turn everything in at the same time. You do step one and step two at the same time. So that's the only exception. If the beneficiary is here already, they enter legally, they're doing adjustment, and they file everything all at once instead of doing step by step. So eventually, it doesn't matter if you're doing it here or abroad, you will be going to an interview. If you're doing it in the United States, adjustment of status, you will be going to the offices at USCIS. Both the petitioner and the beneficiary have to be present. In that interview, you have to take all your evidence, the original documents like birth certificates, marriage, etc. And depending on which type of case you're doing, interviews can take anywhere from, it says 30, 60, I say 20 to 50. Usually the marriage ones are the ones that take a little bit longer. Some cases don't even require an interview, like the ones for mothers sometimes don't require. But even if they do, it's not uncommon to go to an interview here at USCIS. Now, if you go to the embassy for your consulate interview, it's a whole different ballgame. Every country has different requirements on how you prepare your application and how you submit your application and where you do your medical exam. Everything is different depending by country. So Mexico, Ciudad Juarez, for example, has their process. And then Madrid in Spain has their process. And then Buenos Aires, Argentina has their own way of doing it. But generally, you'd be going to an interview as well. These interviews are way shorter because it's a lot more applications that they're seeing. And so the difference here is that when you're at the consulate, they would have already revised most of your application, and they're there just to ask you final questions, which is why the interview is usually very short. So it's usually a 5-minute interview, 10-minute max. They're just checking the information that you put there. Whereas if you do it here, sometimes they're revising the packet for the first time with you. It really depends. But that's the point is that you will be going to an interview here or outside regardless. So if your case is approved, if you're doing it in the US, they will send you your green card in the mail, as easy as that. If you're doing it in the consulate, however, it's a little bit more complicated. They will first put a visa on your passport, kind of like the one you see there. This will be an immigrant visa. This will allow you to enter the US. And once you're in the US, they will send you the green card to the address that you would have told them where you're going to be living. So first you get this visa, you come into the US, then you tell immigration, okay, I'm here, and you get your green card in the mail to the address that you provided. But both ways lead to residency, and both have pros and cons. Some people get to choose which one they're going to do, which is nice, because their conditions are different. And some people want to do it in the US. Some people said, I can't, especially here in San Diego in the border region. It's really, sometimes it's hard to leave family behind if they're being petitioned from TJ. So sometimes having those options is great, but sometimes you don't have an option. Sometimes like this is the only thing you qualify. This is the only thing you qualify for. Also, very brief family-based immigration section. I can literally go on forever about this one subject, but that's what we're trying to do today. Just briefly touch on different ways that people can become a resident. Family-based is the most common. That's the bulk of immigration cases. However, we want to present to you these other ways that people can become residents. The next section is humanitarian relief that is leading to residency. So all of these benefits or relief are really for people that have either faced something in their life where they're either victims at some level or running away from persecution at some level. So these are not obviously going to be accessible to just anyone. They're going to be accessible to these individuals that should be protected because of the situation that they're faced. So not everyone qualifies to them. The way I see it, if you don't, that's great. It means that some of these horrendous things haven't happened to you, but we'll touch base because you need to know that these are available, because sometimes people have gone through things like this and they don't know that something might be available for them. So let's touch base on that. So asylum is a hot topic every single day in immigration. We see all the time migrant caravans seeking asylum coming to the border. And so what does it mean? What does it mean to seek asylum? And so when you're seeking asylum, what you're telling the US government is that you are running away from your country because of a fear of persecution to your person. And this persecution to your person has to be on what international law calls protected grounds. And so you need to be fearing persecution based on your race, based on your religion, based on your nationality, political opinion, or another social group. And so this is where it gets complicated for a lot of people that are trying to seek asylum. is that you need to be facing this situation of persecution. It unfortunately doesn't include overall country conditions. For example, if somebody's country of origin is facing economic um, difficulties, and so the person comes to the U.S. in search, of better economic growth and life, etc. Totally understandable, but in asylum, that doesn't qualify. You need to be fearing and facing persecution to your person because of one of these reasons. And if you don't have that, unfortunately, people can't qualify for asylum. And another thing that's very important about asylum, you need to apply within 1 year of getting to the US. There are some exceptions, but this is a very important rule. So, for example, if you entered on a visa 3 years ago and then you want to apply for asylum, well, 3 years ago is more than 1 year, so you might have missed the deadline to apply. Obviously, if something changes in your country and now you are fearing persecution, then that's where the exceptions can apply. But for the most part, you need to apply for asylum within 1 year. And the application for that is called I-589. And in this application, you need to provide supporting evidence that you are facing the persecution you say you are facing and give credible testimony. If you get asylum approved, after 1 year, you can apply for residency. It's a very clean process, but you do have to wait 1 year until you apply for residency after you get the asylum approved. Obviously, you also need to meet admissibility criteria and maintain your asylum status. Now, refugee, people tend to mix both of these, and they are very similar. But the key difference is one thing, that when somebody comes to the US as a refugee, they already have the status of refugee. The status of refugee is determined outside the United States. And it's similar in the elements of asylum because these are people that are facing the same persecution and have a well-founded fear of persecution in their country because of the same reasons: race, religion, nationality, political opinion, or social group. The key difference here is that their persecution was verified by the United Nations. And so in their country of origin or out in the outskirts of their country of origin, if they're fleeing the country, they would have been identified as refugees by the United Nations, and then they would have been sent to the US already with refugee status. And so a lot of people said, can I apply to be a refugee? No, you can't, because you need to have already been a refugee. You need to apply for asylum. So the people that are facing the same situation but don't get given the refugee status, those are the people that apply for asylum. And so it's a key difference. Refugees enter with status, asylees have to fight for their status. And just like asylees, once a refugee enters the U.S. and have been here for over a year, they can apply for their green card, and it's a very simple process for them as well. They just need to meet, their admissibility criteria. Now we're going to talk about some visas that lead to residency. This one is the U visa. This is for victims of crimes. If you have been a victim of a crime or a close family member has been a victim of a crime in the United States, and the crime is one that immigration calls a qualifying crime, some examples can be domestic violence, sexual assault, then you can qualify potentially for a U visa. You need to cooperate with law enforcement in the investigation and the prosecution of the crime, and you must have had some information that helped law enforcement, capture these criminals. The crime needs to be needs to be the police need to verify the crime. They need to certify. Sorry, I was using the word certify. There's a certification process that the person was a victim of this crime. This is a very, very long and tedious process. It takes years. While the person is waiting for the decision, they can get a work permit. And if they do get the U visa approved, after having it for 3 years, they can apply for residency. This is a very long and tedious type of case, but it's a very real way to become a resident. And so if you know anyone that has been a victim of a crime here in the US, send them our way. They might qualify for a U visa. Next is T visas, and very similar to U visas, but this is specifically for victims of human trafficking. Human trafficking is not necessarily just sex trafficking. It could also be forced labor, which is more common than you think. And if you have been a victim of human trafficking at any level, you could potentially get a T visa if, again, you cooperate with law enforcement in the investigation, and you demonstrate that you had harm made to your person or psychologically due to the trafficking. And if you do get a T visa, again, after 3 years, you can apply for a residency. So it's very similar to the U visa, but you need to have instead been a victim of human trafficking. We also have SIGIS, which is Special Immigrant Juvenile Status. This is for children. Sorry, talking about children, and my baby knocked on my door. So you need to be a child. You need to be under 21, and you need to have been declared a dependent by juvenile court. And you being declared a dependent obviously means that you don't have your parents with you, and you need to have been a dependent because of abuse, abandonment, or neglect by one or both of your parents. This could have been in your country of origin or in the United States. And you need to prove that returning to your home country would not be in the child's best interest, would further cause harm to the child. And so if you are able to get SIGIS status, you can apply for a green card directly as a minor. Once the juvenile court finds that you are in fact you were a dependent and that you were a victim of abuse as a child. So there are different criteria to this. The important part here is if, we see a lot of unaccompanied minors and the cases that they've faced, and there are legal pathways like SIGIS for them to be able to maintain residence here in the US. Then we have VAWA, which means Violence Against Women Act. This is another relief that is for victims specifically of domestic violence and by the hands of US citizens or residents. And they could have been by parents or by spouses. You need to prove that you were in a good faith marriage if it was through marriage. And you need to have evidence of abuse. So very similar to the U visa where the police need to certify. There's no certification here, but there needs to be police involvement in reporting, and them certifying that there was a domestic violence claim against the person that perpetrated it. And this could also be for parents. A lot of people don't think that it's for children that were abused by their parents, but it could also be. So any form of domestic violence, man to woman, woman to man, parent to child, could potentially qualify for VAWA. And people that do get VAWA can self-petition for themselves and get residency that way. So this is another avenue for residency for humanitarian cases. So like I said, these aren't, your happy cases. These are really for people that have faced extraordinary and unfortunate circumstances, but it's important to talk about them because there's real relief for them out there if they have been victims of these situations. Um, I'm going to touch now on employment visas just to highlight them to you that they do exist. Um, Here at Alliance and most nonprofits that do immigration work don't do employment visa. Most of us do family-based and humanitarian. But it's good to know because we want to touch base on different ways to become a resident, and employment visas leading to residency is one of them. A lot of people do it this way. Um, so there's a lot of different work visas. And so when somebody has a specific type of work visa, eventually down the line, that work visa can become a residence. And so it's really important to know which visas can turn into residence. And so, first of all, the employment visa program was started for foreign nationals seeking employment in the United States. And so the key categories, the key visa types that can become residents are the EB1, which are priority workers, EB2, which are advanced degree professionals, EB3, which are skilled workers, professionals, and other workers. So if you have any of these visas, the way you get them is by an employer sponsoring you most of the time, and it's through USCIS. So if your employer, you find an employer and they petition you and you get your work visa, you can be here for a prolonged period of time with your work visa, but eventually that work visa either expires and you have to go back to your home country, or it can become a residency. So all we want to let you guys know is that uh, some of these employment visa categories can become residency, and it really depends on your employer and the willingness of your employer to, first of all, petition you as to get your work visa, and then petition you to become a resident. So we talked about family petitions and how it's a family member petitioning you to become a resident. Here would be an employer petitioning you to become a resident. So the times vary and they're very complicated. Most of these, well, they're not complicated, but most of these applications are done in the private world. They're mostly professional type of employment. We don't handle that a lot, but if you do have a situation where you're interested in this type of case, we can still provide a successful referral to you to see if that can lead to residence for you. All right. Moving on to a very unique way of becoming a resident, which is the diversity visa lottery. I've been doing immigration work for almost 10 years now. I've only seen 2 diversity visa lottery cases, but they do happen. And so I think it's important to talk about the diversity visa. The purpose of the program is to diversify the U.S. immigrant population, believe it or not. And it's an opportunity for low immigration country natives to come into the United States. And so what this means is that the diversity visa is available only for people of specific countries where there are not that many people of that country in the US. And this is something that you can check online to see what countries have diversity visas open. And there are requirements you need to have. You need to be a native of that country. You need to have certain education and work experience requirements. And every year there is an online entry period. So what you're literally doing is if you qualify to enter this, if you're from that country, you meet the education requirements, you enter into a lottery. And every year they pick an X amount of people, and you have been randomly computer generated. You were selected, and you are now able to apply to an immigrant visa. As easy as that. You literally just have to be lucky and from that country. And they're not that common, but they are very exciting to see a client that got their residency through diversity visa. They always tell you a story of how they found out or what they were doing. it's very exciting because there's no need for the petitioner. There's no need for immigration background, and it's just you literally win a lottery and you were invited to become a resident. So this is just more details. Obviously, there's a whole application process that goes behind. You need to be able to prove that you're from that country. You need to timely apply because it's all online and there's a application period. You need to be checking to see if you got selected. And once you are selected, there is a whole very similar to if you're getting petitioned, there's a whole process of proving that you are a person of good, that hasn't committed crimes, that has a valid medical record. So you still go through this interview, just like we were talking about for the other cases. But the way you got there is just very different from the other ways that we were explaining before. The way you got to the interview is literally through a lottery, but you still need to clear all these requirements to become a resident. So yeah, that's an exciting one. This is not a exciting one, but I still want to talk about it. If you are in a situation that you fall into removal proceedings, there's also ways for you to either remain a resident or become a resident after not being a resident. So even though removal immigration court is very stressful, it can have a very positive outcome for you. So we want to talk about it a little bit. This is 2 forms of relief that you can apply for. This one is a little bit cheating, but I wanted to include it in there because this is for people that are already residents. So if you're already a resident and for whatever reason you fall to immigration court, either because you committed a certain crime or something happened that you're in immigration court. When you're in immigration court, what's happening is that immigration wants to know if they're going to deport you or not. And you need to choose what relief you want to be deported. So to stop you from being deported. So cancellation of removal for legal permanent residence, which we call 42A, is that form of relief. So if you're a resident that got in trouble and you're in immigration court, you can apply for this. And if you have been a resident for 5 years and you have been living in the U.S. for at least 7, and you don't have any serious crimes like aggravated felonies, and you're a person of good moral character, and more importantly, you have an extreme hardship to your family members if you were to be deported, then you can win your immigration case and remain a resident. So there's a lot of requirements, and I'm really doing this super briefly. They're very complex cases, but essentially what you're doing is proving to immigration, to the judge, that if I get removed, my family members are going to suffer tremendously. And not just that, I am also a good person because I don't have all these records. I have a lot of people that say positive things about me. And I've been here for an X amount of years. So if you can prove all of that, then you maintain your residency. And so you are given one more chance to be a resident in the United States. So that's one removal relief, which is technically how to remain a resident. The one I really wanted to touch on is 42B. This is the same concept, but for non-residents. So if somebody is undocumented and they fall in removal proceedings and they have to go to immigration court to fight their case, this is the relief that they're going to be seeking, 42B. And for 42B, the requirements are a little different, they're a little bit stricter. So you need to have been physically present in the US for the last 10 years. And you need to have maintained good moral character during this time. You also need to prove, and this is quoting, exceptional and extremely unusual hardship to a qualifying US citizen or resident family member. So just like the 42A or the 42B as well. Exceptional and extremely unusual hardship is the bar which is really high. It's higher than immigration waivers, like for other things. It's one of the highest bars. And you also need to not have had any aggravated felonies. So you have to go to court. You have to obviously prefer to be represented in court. You need to attend your court hearings and provide evidence that you are eligible for the 42B. And if you are eligible for the 42B, you go from being undocumented, seeking, facing deportation to green card. Not only do you not get deported, but you get a green card, you get a residence. So it's a way to become a resident. Obviously, being in immigration court is a very stressful situation that you wouldn't want to purposely be in. But just know that if you do win your case, you're not going back to being undocumented again if you apply for a 42B and you got it. What you are going back to is now being a resident and eventually, if you want, a citizen. So it's a very good way for an undocumented person to go from being undocumented to being a resident. In removal proceedings, and I just wanted to highlight this, you can also apply to some of the relief that I was talking about. So you can also apply for asylum in court. You can also apply for special immigrant juvenile status in court. And you can even do adjustment of status, which is applying for residency through a family member in court. So all these things could happen in court as well. I just wanted to highlight that. And those could also lead eventually to residency. All right, last section, I'm gonna keep it a little brief. Avoiding fraud. So it's really easy to face fraud here in the United States, unfortunately. What I want you guys to do anytime you go to a consultation about immigration cases is to check people's credentials. So if they're telling you that they're an attorney, you can go to calbar.ca.gov to check if they're an immigration attorney in California. If you want to check if they're accredited representatives or accredited agencies like us, like me, myself, and Andrea, you can go to justice.gov and you'll find Alliance there as an accredited agency, and you'll find Andrea and me there as accredited reps. So it's really easy to check people's credentials. That should be step number one when finding immigration help. You would also, of course, want to avoid notarios, since they're not. The only two people that can represent you are attorneys and Department of Justice accredited agencies. So you want to avoid anything that is not that. And anytime you get legal help, you always have to get a written contract, and you always need to be provided copies of everything that you are doing. So these are just some tips for you guys to avoid fraud. And when you finally do find a place and you're preparing a consultation to see if you qualify to any of these things we talked about, you want to be prepared. You want to have this information already known to you or written somewhere. You want to know how many times have you entered the U.S. and how you entered the U.S. You want to know if you've been petitioned or your family members have been petitioned before. If you've been in immigration court, you have to know when and what happened. If you already have an immigration number, which is called an A number or USCIS number, you want to have that information so that we can check your case. Any contact with any law enforcement official like immigration or the police, we're going to want to know because it can affect your eligibility. And also where you work can also have some importance. So you need to have all this information on you for you to have a successful consult. And what you want to leave with from the consult with is, do you have a remedy available to you now? Like, can you apply for something now and get residency now? And if you can, what is this process? What do I need to do to start my case? And then there's no remedies available, unfortunately. So you want to know, do you have remedies in court? Like if something were to happen in an emergency, can I do something in court? And if I can't, then what are my next steps? How do I prepare for potentially something in the future? So this is what you want to leave the consultation knowing, which is important. All right. we are pretty much done. We will take questions for you now. This is our phone number, 619-269-1823, extension 426. Email us immigration@alliance.org. If you guys have any questions, if you guys need consultations, please let us know. Andrea, do you have any questions from the crowd out there that you want to ask me?
Yes, we have a question. It says, hello, is there any law or regulation for people that are, I think it meant to say undocumented, or no, for people that are documented but have been more than 20 years and they work and pay taxes and have their own home?
So if I understand correctly, it's probably for undocumented individuals. So the question is, if I have been undocumented for over 20 years, but I work and I pay taxes and I have a house, is there something available for me? Uh,
Correct.
Unfortunately, the answer to that is not based on those characteristics. Like the fact that you have been here an X amount of time and work and pay taxes doesn't make you eligible to certain relief. Um, like I said, most of the ways that people become residents we've touched on, the bulk majority is family petitions. Then there's a humanitarian, and then there's all these other smaller ways of becoming residents. Unfortunately, there's no way for you to petition yourself, and prove that you've been here for X amount of time and have been a good model citizen, and therefore deserve it. Which we totally agree. We always advocate for immigration reform for all the 11 million undocumented individuals in the US, but unfortunately, there's no path right now where one can petition themselves and start a green card process. The last time that was seen was in the Reagan era, that was with amnesty, and that was for people that have been here before 1986 for an X amount of time. So it's been a while, and we're hoping that it happens again so that a lot of people can apply for residency for the first time. But thank you for the question. Is there any other questions, Andrea?
No, not at the moment. We don't have any other questions.
Okay. Well, if you have any other questions, please let us know. Thank you so much and have a good rest of your evening. Bye bye.